Hi class, this is Dr. Shahada, and in this video I'll be going over Chapter 12 on healthcare quality, policy, and law. So in this chapter there are a number of different topics that are covered. It includes licensure and accreditation in the context of healthcare quality. It describes the scope and causes of medical errors, as well as the meaning and evolution of the medical professional standard of care. And it also identifies and explains certain state-level legal theories under which healthcare professionals and entities can be held liable for medical negligence. It also explains how federal employee benefits law often preempts medical negligence lawsuits against insurers and managed care organizations, as well as describes recent efforts to measure and incentivize high-quality health care. Now, quality really has brought to the center stage, or a lot of attention has been on the idea of quality of healthcare since the 1990s, when cost containment became a big issue and was trying to be implemented. And because people were worried that kind of taking these cost containment strategies will negatively impact quality. So here in this slide, we're talking about quality control through licensing and accreditation. Now, before I jump into the specific topic, I do want to clearly define quality as it's defined by the Institute of Medicine, which is the degree to which health services for individuals and populations increase the likelihood of desired health outcomes and are consistent with current professional knowledge. I wanted to clearly state that just so we're all on the same page of what we're talking about when we're speaking about quality. And there are different dimensions of quality, but right now I'm going to continue with this slide and we'll go back to that later. All right, so the licensing of healthcare professionals and institutions is a very important function of state law. So it really filters out those who don't have the knowledge or the skills to practice medicine. And when exercising these police powers on the state level, it includes applying licensure laws in order to protect residents from being subjected to substandard health care. So these state licensure laws, they define the qualifications required to become licensed, as well as the purposes of maintaining and renewing licenses. And this licensing function has really been used to promote healthcare quality in order to make sure that those providing healthcare services have the knowledge needed to provide such services. All right, so now in the next slide, there we go. All right, so we touched on the top point, but private professional and industry ethical and practice standards exist, even though they really don't affect day-to-day quality. It tends to be debatable. An example of this is the whole topic of accreditation. So there are some people that don't feel that accreditation plays a very important role, while others find it to really stand alongside the whole concept of licensure. Some examples of these healthcare accreditation bodies include the Joint Commission, which is actually formally known as the Joint Commission on Accreditation of Healthcare Organizations, which may be best known for its review and accreditation of hospitals. There's also the National Committee for Quality Assurance, which accredits managed care organizations. Then you have the Healthcare Facilities Accreditation Program. There's also the Commission on Accreditation of Rehabilitation Facilities. And there are others, but just to kind of give you an idea when we're talking about these accreditation bodies who we're speaking of. Now, state licensing schemes actually were designed not with the whole concept of healthcare quality in mind, but really to protect medical professionals from incompetent providers and bad publicity. Now I am going to jump to the next slide. So licensure plays an important role in defining the permissible scope of practice of the various types of healthcare providers. All right, so in the next slide, we are going to be covering the topic of medical errors. Medical errors represent a very serious public health problem, and they really pose a threat to patient safety. So it's estimated that about 44,000 patients die in American hospitals each year because of medical errors, making adverse events the eighth leading cause of death in the U.S. So the extent to which medical errors both occur and result in these adverse health outcomes and mortality really indicates that the problem isn't confined to an ethnic or racial population or a socioeconomic group or even a geographical area. And one of the sad things that was actually pointed out in our textbook is that overall more people die each year from medical errors than from motor vehicle accidents, breast cancer, or even AIDS. So the negative effects of medical errors on individual patients and on society as a whole, including associated reductions in work productivity, lost income, and the costs associated with correcting injuries resulting from errors, really supports the conclusion that medical errors are properly classified as a public health problem, requiring a strong response from policymakers and the legal system. So in the next slide, we are going to be covering the causes of these medical errors. Now, there are a couple of causes as listed here: failure to complete an intended medical course of action, implementing the wrong course of action, using faulty equipment or products, also failing to stay abreast of one's field of medical practice, health professional inattentiveness, and the list really does go on. I do want to quickly say, just do not look at the last two bullet points there. Ignore that. I didn't realize that I didn't take that out. I do also want to mention the Agency for Healthcare Research and Quality. They identify 4 types of medical errors that go along the lines of these causes of medical errors. One is medication errors, adverse drug events, which are errors in prescribing and administering medicine to patients. There's surgical errors in performing surgical operations. There's diagnostic inaccuracies, which may lead to incorrect treatment or unnecessary testing. And the fourth is systematic factors such as the organization of healthcare delivery and the distribution of resources that can contribute to a preventative adverse event. All right. So policymakers, they've begun shifting their attention to medical error reforms that are less reactive and more centered on error prevention and patient safety improvement. And the 2 primary objectives of these reforms include the redesign healthcare delivery methods and structures to limit the likelihood of human error and prepare for inevitable errors that will occur in healthcare delivery, regardless of the amount and types of precautions taken. All right, so to the next slide. So here we are covering the topic of promoting healthcare quality through the standard of care. So the professional standard of care is the legal standard used in medical negligence cases to determine whether health professionals and entities have adequately discharged their responsibility to provide reasonable care to their patients. So this type of liability falls under the law of torts, which is a term that's actually derived from the Latin word for twisted and applies to situations where the actions of an individual or an entity twist away from being reasonable and result in harm to others. Now, tort is another word for personal injury or a civil wrong suffered by one person owing to the fault of another. Car accidents and slip and fall accidents are considered torts in the eyes of the law, and so are medical malpractice incidents, where a healthcare provider's negligence or carelessness brings harm to a patient. So proving tort liabilities is not easy generally, and this is no less true in the specific context of medical care. So if a patient seeking to hold a health professional or entity responsible for the substandard care or treatment, they have to demonstrate the appropriate standard of care. They need to demonstrate that there was a breach of that standard by the defendant, and measurable damages, for example, physical pain or emotional suffering, and a causal link between that defendant's breach and the patient's injury. I'm going to jump to the next slide because I actually just covered that. So again, here are the different points that a patient seeking to hold a health professional responsible for substandard care or treatment must demonstrate. All right, so in the next slide here, it shows the standard that has actually its origin through 18th century English common law, where the courts in England established that a patient looking to hold a physician legally accountable for substandard care actually had to prove either that the doctor violated the customs of his own profession as determined by others within the profession, or that the testimony provided on behalf of a patient as to whether a physician's actions met the standard of care could only come from physicians who practiced within the same or similar locality as the physician on trial. Now, with time, these standards were updated by courts. So courts now consider a range of relevant evidence to really determine whether a health professional's treatment of a particular patient rose to the standard of care, is whether it was reasonable given the totality of the circumstances. So now the physician's actions are actually measured objectively against those of a reasonably prudent and competent practitioner under similar circumstances, not against the actions of physicians who practice within a particular defendant's locality. And then we have a concept mentioned in the chapter known as vicarious liability. And this really refers to a situation where someone is held responsible for the actions or omissions of another person. So this is where one party can be held legally accountable for the actions of another party based solely on the type of relationship existing between both parties. So an example of vicarious liability is that it allows a hospital to be held responsible in some situations for the negligent acts of the doctors that practice medicine under its roof. Not because the hospital itself somehow acted negligently, but rather because the doctor is an agent of the hospital. Then in the next slide here, we have the general rule is that employers are not vicariously liable for the improper actions of independent contractors. However, there's been courts that have developed exceptions to this rule, and which examples include actual agency and apparent agency. So it's more concerned with the scope of a relationship than the formal characterization of the relationship as determined by the parties. Now, next is the concept of corporate liability. Now, as opposed to the vicarious hospital liability, which is predicated on the negligence of individual health professionals, when we're looking at corporate liability, it really holds the hospital accountable for their own institutional acts or omissions. So the idea here is that a hospital can also be held liable when its own negligent acts as a corporation contribute or cause a patient's injury. So several general areas give rise to litigation around entities' direct quality of care duties to patients. So here it includes failure to screen out incompetent providers, failure to maintain high quality practice standards, failure to take adequate action against clinicians whose practices fall below accepted standards, and failure to maintain proper equipment and supplies. So in this chapter, they cover a very popular, very famous hospital corporate liability case known as the Darling versus Charleston Community Memorial Hospital case. And it revolves around a patient. His name was Dorrance Darling, 18 years old, who had suffered a broken leg playing college football. Came to the hospital's ER, and they had improperly put a cast on his leg, which actually led to cutting off blood circulation, ultimately resulting in an amputation of that leg from the knee down. Now, in this specific case, the court actually held the hospital liable not for the actions of the emergency room staff, but for its own negligence. According to the court, that Memorial Hospital did not maintain a sufficient number of qualified nurses for post-emergency room bedside care. So that was the Darling versus Charleston Community Memorial Hospital case. Now, I'm going to wrap this video lecture up. I don't want to get it too long, but I do want to remind you guys to make sure to read the whole chapter. I do want you to be familiar with the Employee Retirement Income Security Act that's covered in the chapter, as well as the sections that cover measuring and incentivizing healthcare quality. Make sure to go through the rest of the slides in this presentation. I wanted to make sure to cover some of the areas covered in this PowerPoint presentation. And if you have any questions at all, don't hesitate to let me know. All right, everyone, take care. Bye.